for entertainment purposes only. And if you want true legal advice, contact your own lawyer.
Yeah, we've got Alabama, Arkansas, Georgia, Louisiana, Mississippi, Oklahoma, South Dakota, Texas, Utah, and West Virginia have joined the NRA in trying to defend the Gunmaker in the Sandy Hook liability appeal. Let me back up and tell you what happened here. A lawsuit comes before, let's back up to 2005. 2005, federal government passes this law, which is called the Protection of Lawful Commerce in Arms Act. Now, I'm just going to go tell you generally. That means it's basically under the Second Amendment protecting manufacturers so they're not sued all the time when there's a shooting and someone dies. Okay, that's basically what it is. I know everyone's like, oh, there's details. I'm not going to get the details right now. We're talking generally. So under this, most of the time, if someone tries to sue Remington, Colt for something, it gets thrown out by the courts the majority of the time, or almost all the time, because they're saying, look, this act of 2005 protects the manufacturer.
Right, and the reason for the protection of the manufacturer is because in the Second Amendment we have the right to bear arms, so they feel like they have to protect the manufacturers who make the arms so we can have our Second Amendment right.
Right, and then otherwise it put them out of business. Let's face it, they'd all be out of business, and that's the argument. So what happens is, and Todd brought this up, but I'll bring it up to you, Denise. So there's they've filed what's called amicus briefs. That is these 10 states. And an amicus brief, Denise, tell them what an amicus brief is.
Well, amicus means friend of the court, actually. So what you're doing is you're filing a brief to state a position in support of one or the other of the parties that are before the court.
Right. In other words, hey, I'm a friend. I have some issues here with this too. I'm going to come in and file also, and they have the right to defend. And they'll make their argument.
It comes up a lot when somebody is following a particular case, and when they read things that have been filed, a lot of times they realize nobody talked about this issue. An example would be a Supreme Court ruling on drunk driving laws that came out about 5 years ago. They focused on alcohol-based DUIs. Nobody filed any brief about what do you do in a drug-based DUI. That would have been a good one for somebody to look at and file. That's why we get these.
Good, that's exactly right. So what happens in Connecticut is the lawsuits are filed. This is way back in 2012. The lower court throws it out. Said, look, you got the 2005 Protection of Lawful Commerce in Arms Act. You got the Second Amendment. You're not going to be able to sue Remington. And then it goes all the way up to the Supreme Court of Connecticut, who overturns it and says, now remember this, everybody, and this is what we have to make sure you understand is, they did not win the case. Everyone says, oh, they won the case at the Supreme Court of Connecticut. All Connecticut says is, yes, you can go to trial on this. They didn't throw the case out. It doesn't mean they win. They just said, yeah, jury can hear this.
And it was a really close call, too. The Connecticut Supreme Court ruled 4-3 that the case had to be reinstated.
And go to a jury to hear.
That's right.
And so that is being appealed right now, whether or not they are allowed to, that it should have been thrown out in the first place. And so what I want to note down is what they did and how their argument occurred. And what happened was they argued a very narrow exception in the law, which basically says if they're intentionally, that is the Remington or Colt or whoever, are targeting in advertising some way that is improper, that's a little tiny loophole they can come in and get them. So their argument was, and what the court held in Connecticut was that, and this is their allegations, it targeted younger at-risk males in their marketing of this AR-15 and the product placement in violent video games. And through that little loophole, they were able to argue and say, therefore it falls out of the Protection of Lawful Commerce Arms Act, and they can be sued under
state law.
Under state law.
Yeah.
Cal.
I am so lack of intelligence on this, so please don't make fun of my question, okay? I admit that I'm a dope, so please don't make fun of my question. So, Kylie Ray Harris, country singer, driving along a road to New Mexico, drinking alcohol, gets in a crash, kills a 16-year-old. Do you think that alcohol is marketed to young people as being sexy? Oh, I don't know. Look at the ads. You can make up your own mind.
Right.
Yeah, but she wasn't driving. Do you realize that?
But I think his point is that alcohol is also,
inherently dangerous.
The alcohol, the car she was in, are they not marketed to young people? Have this car to look sexy and cool?
Yeah,
So I'm just trying to think out loud here. Would not someone in Connecticut say, Your Honor, the vaping thing that's now starting to kill people with the contaminated oil, allegedly? They could say, Your Honor, this is just how marketing works, Your Honor.
Well, this is how it's been for cigarettes for a really long time.
Yeah, so how does that work?
So here's the point. So the argument would be those who are arguing that the manufacturer should be liable would probably turn to you, Cal, and say, You're right, Cal. They should be sued too.
Then go for it.
That's what I'm trying to say.
What about the iPhone texting? Let's get her done. But nobody has.
I don't know that the iPhone can shoot anyone. Go ahead.
Well, I look at it this way. I think the question here is, what does it mean to be marketed towards somebody? For example, the marketing towards individuals when it comes to tobacco, drinking. I mean, these were commercials where people were having a commercial was out with the idea that, and at the end of the commercial, the call to action. In ads, we have what's called a call to action. The call to action is, and buy this brand of cigarette or buy this brand of alcohol and whatnot. The question, I think, is placing a product in a video game a call to action to purchase that? And if you say that it is, then we have a very slippery slope, because that should open up liability to everybody who has a machine gun in a movie, everybody that has a weapon in anything that anybody can see,
a bomb,
and that gets to be very difficult because it's hard to draw the line.
And I distinguish it because when you're in a video game, you're playing the game. It's interactive. When you're watching a movie, you're watching the movie. You don't interact in the movie. And I see there's a difference there. And so if you have the video game that has this assault rifle being used, I know it's not an assault rifle, but it's basically that type of a thing, and you're killing things in this video, that's direct marketing on people who want to shoot other people.
So should the video game manufacturer be liable too?
That's the question, don't you think?
I think that if the slippery slope would certainly lead to that. The only way I would disagree with what you say about being in the game where you're playing it versus not being in the movie. Look, people cry in movies all the time. People get emotionally involved in movies. If a movie doesn't draw you in as the viewer like you're in it, then it's not a very good movie. The best movies are the ones that do. If I'm watching, my ex-wife will tell you this, we could never watch a scary movie in my house because even though it's happening on that box in front of me, I'm still the wingnut over there with a pillow over my head, looking at my phone trying to detract my attention because I get scared based on what I see.
Well, anyway, this best.
You're not going to shoot somebody because of that.
Yeah.
Well, look, if somebody came up behind me and said, boo.
Well, here's the issue here. So the issue is this is coming up. The United States Supreme Court has taken it up.
Yeah.
They are now filing briefs. It's going before the Supreme Court. This is a very interesting case, especially given the latest and newest Supreme Court justices that are supposedly more conservative. Let's see what happens. But this is going to be an important one.
And again, they're not deciding whether or not the guns are legal. They're not deciding whether or not the
Remington is guilty.
Remington is guilty.
Yeah.
All they're deciding is whether or not this is they can be sued, whether or not this can go to a trial.
Right.
And this is a fight between state and federal laws. So this is going to be a fun one to watch. And we've got 10 states that are, hey, states' rights. We want to protect the guns, and we've got other states that have filed amicus briefs saying it should go on.
Yes.
So it's a definite
but again, do not think
conflict.
that, they won even if the United States Supreme Court agrees with the Connecticut Supreme Court. All that says is, yes, you can take it to court.
Yeah.
That's all they're saying.
Go to the website, radiolawtalk.com. That's radiolawtalk.com.